We will go on the record in the matter 26 CM 84, State of Wisconsin versus Shanna Corbine. The state appears through Assistant District Attorney Jose Vila in person. We have Daniel Chapman, Defense Counsel, in person with Ms. Corbine. We're set today for a status conference. Mr. Chapman, can you update the court?
Your Honor, I was just appointed, I believe, on the 6th. I do have an offer, but I don't have discovery yet, and I believe that the matter will be resolved. I just need to actually look at the evidence.
Okay, all right. Holy guacamole, man. I can do September 28th, 10:30.
That works for me.
All right, you can come get your notice and you're free to leave. We're off the record. When are you going to be able to make that deposit?
Pretty soon. Pretty soon.
What does pretty soon mean?
This next payday, I will for sure.
Okay.
Something.
And when's your next payday?
I haven't gotten it
When,
yet, but if we
well,
don't
I get paid
one,
on Wednesday.
it's gonna be
Next
an
Friday,
honesty.
2 Fridays. Or wait, not this coming up one, but the next one.
So on the 31st?
Yes.
Okay, make sure that you have it paid then by the 4th of August.
Okay,
All right?
thank you.
Yes, September 28th at 10:30. You can just come on up and Mr. Eads.
Yep. Have a good day.
Thank you. Okay, just give me 1 second. We will go on the record in the matters 25 CF 127, 25 TR 780, 837, and 838, State of Wisconsin versus Michael Eads. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Eads in person with counsel Daniel Chapman. We're set today for status conferences. We do have a plea and sentencing scheduled for October 1st. Are we still on track for that, Mr. Chapman?
We are, Your Honor. Mr. Eads is still in treatment following the conditions of his bond, and we are still on track for a plea on August 1st or October 1st.
All right. And I can't recall, was there an agreement to a collateral attack, or were you not able to find one?
No, Judge, there is no collateral attack issue.
Would it be OWI 5 or
Yes.
6? Okay. All right. So then we will see you on October 1st. You can come up here and get your notice and you're free to leave. Thank you.
I believe those are my only 2 1 o'clock matters, right, Judge?
I have Mr. Morales. I may have appointed him to you. Yes, I've appointed him to you.
Yes, I have
Amy?
him. I just didn't realize he was at 1 o'clock.
Yes, he is right there. If you need to speak with him, you sure may.
Have I been appointed on his new matter, Judge?
You have been appointed, well,
I've been
on
appointed on-
26 CM 32.
Right. Come on up, Mr. Morales.
And then he has a CT 35, which the court will appoint you on that as well.
Give me a call if you need anything, okay?
We will go on the record in the matters 26 CM 32, 26 CT 35, 26 TR 04, and 19. State of Wisconsin versus Antonio Morales. The state appears through Assistant District Attorney Jose Vila in person. Mr. Morales appears in person with counsel Daniel Chapman. We're set today in these matters for initial appearances. We do have the newly filed 26 CT 35, which is another OWI second allegation. Mr. Chapman, do you need a copy of that criminal complaint?
I have not seen it yet, so yes, I would appreciate it. I have discussed it with Mr. Morales.
You can come up here and get a copy.
Okay.
Mr. Morales, you are currently behind on your payments, about $300. When are you going to be able to catch up?
I did not know anything about that. I can pay it as soon as possible. I just got done paying $385 today for setting up this intoxicated driver intervention program. But I believe I should be able to pay the $300 by probably next week.
All right.
hoping. If not next week, for sure the week after.
I can give you until August 4th to get all caught up.
Okay, that'll work for me.
Okay,
And you said it's just 300 that I owe?
100.
Okay.
yes. All right, were you able to go over that criminal complaint with Mr. Morales?
I just read it myself, Judge. A quick skim shows no conflicts that I can see. I did discuss earlier with Mr. Morales the fact that he was charged with another OWI and specifically what the possible penalties would be if one became a third offense. He understands what he's accused of and what the penalties are.
All right, so not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. We need a status date. September 28th at 10:30, September 28th at 10:30.
Yes, Judge.
I'm going to presume you're going to discuss and look at this once you get discovery here and try and see if you can get some type of global, if that's possible.
Yes, Judge.
He's already doing the IDIP, so we'll just get a status on that then. You can come up, get your notice, and you're free to go.
Thank you, Your Honor.
Okay.
Don't forget that August 4th date, okay?
Okay, I won't.
Now I'm going to go speak to Ms. Bule.
We will go on the record in the matter 26 CF45, State of Wisconsin versus Crystal Bule. The state appears through Assistant District Attorney Jose Vila in person. Ms. Bule appears in person with counsel Daniel Chapman. We're set today in this matter for a status, but this was also set as a potential plea. Mr. Chapman, I've been handed a plea questionnaire waiver of rights form, so I'm going to guess it is going to be a plea in sentencing today. Can you please recite the agreement on the record?
Your Honor, Ms. Bule will be pleading guilty to the amended charge of possession of amphetamine. The other two charges will be dismissed or dismissed and read in either way. And there will be a joint recommendation for costs only. She is already on probation and she is in drug court.
All right, in Washburn County? Yes. Okay. So I do have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
And is that the agreement that you've reached?
Yes.
Mr. Vila, formal motion to amend to a possession of amphetamine?
So made.
Granted. Did your attorney thoroughly go over this document that is essentially word for word?
Yes.
Is that your signature on the second page?
Yes.
You're pleading guilty to one count of possession of amphetamine. You're 43. You have 12 years of schooling. You can read, write. You understand the English language. No treatment for a mental illness or disorder except for AODA, correct?
Correct.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did he go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on the first page. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
I'm a citizen.
I have to ask that to everybody. Do you understand that the state would have to prove on or around April 20th, 2026 in Burnett County, Wisconsin, you possessed a substance, the substance was a controlled substance in an amphetamine classification, and you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would have to prove? Do you understand the maximum possible penalty could be a fine of up to $5,000 or up to 1 year of incarceration or both?
Yes.
Do you understand that there is an agreement here for costs only, but do you understand I'm not bound to follow that?
Yes.
That means I could sentence you to that maximum penalty if I thought it was warranted.
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did your attorney go over with you the criminal complaint and those facts that allege those crimes that were committed?
Yes.
For the most part, are those facts accurate?
Yes.
Admitting here today you in fact did possess an illegally controlled substance?
Yes.
And it was in an amphetamine classification?
Yes.
And you knew that?
Yes.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Ms. Bule, for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes.
And voluntarily?
Yes.
Has your attorney represented you competently? Has he answered all your questions?
Yes.
You're satisfied with the services?
Yes.
Any questions for the court or your attorney before I proceed?
No.
As to amended count 1, possession of amphetamine, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count 1. Counts 2 and 3 will be dismissed for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. Ms. Bule is here taking responsibility for her actions. The nexus of this case is that this was really a personal substance abuse issue. She was cooperative with law enforcement on the scene regarding that personal substance abuse issue. And as Attorney Chapman already noted, she's going to be on probation out of Polk County for at least the next 2 years. Similar situation for personal substance use issues. As such, I think, given the fact that she's going to be on supervision for another 2 years, time cost is most that are appropriate here, and the needs to protect the community are more than satisfied. I would ask the court to adopt. Thank you.
Thank you. Mr. Chapman.
I would just add that the obstruction behavior in this case was mostly directed by the driver of the vehicle. And in fact, Ms. Bule tells me that every time the police officers left the vehicle, she was telling him, no, you need to get out. They're going to break my window. He was just refusing, and she was just sitting there quietly. Also, she spent about 2 weeks in jail after this due to a probation hold.
All right, thank you. Anything you want to add or you want to state to the court, Ms. Bule?
No.
Are you currently employed?
Yes.
Where do you work?
I work at the Prime Barn.
Oh, that's good. Okay. So you are employed, and do you work part-time, full-time,
It's kind of, I guess, full-time.
$12 in tips?
Yeah.
Okay.
Well, actually, I make $6.
Oh.
Tips.
Oh, because you're bartending.
No, I don't bartend. I'm just a waitress, and I.
Waitresses only make $6.
Yeah.
I could have
Yeah.
swore I just had a case where somebody worked at the Prime. She made $12 plus tips.
Maybe if she was a dishwasher or a hostess.
I
know.
swear
When
she
when
said she was a
waitress-
bartender and or waitress.
Oh, yeah, I make $6 as a waitress or $12 as a dishwasher.
Okay, all right. Well, either way, you make some money. This isn't that serious. It's a use case. Sounds like you're in treatment court and you're going to be on probation for 2 years. I'm willing to waive some costs and fees here and only do the DNA surcharge, but I'm going to tell you, and I'm going to tell you right now, if you don't pay this off and you don't pay your monthly payments, I will issue a warrant and you will sit more time for failing to pay, okay?
Okay.
So I will only assess the DNA surcharge of $200 because quite honestly, you're taking care of this very quickly and I'm going to give you a benefit for that and I want you to succeed. And so I'm going to waive the $243, but only assess the DNA surcharge of $200. I'm going to order that you make payments at $50 a month. First payment due in August. So by the very last day of August is your first payment due. But again, if you fail to pay, not only will I enter a civil judgment against you, I will issue a warrant and you could sit up to 6 months in jail. I watch fees and payments like a hawk. Okay, so make sure you pay that because that is part of your sentencing. And that's exactly what this is. And I'm giving you a benefit of waiving some of that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm going to order 10 days of jail time served. You sat it. I don't care if you get credit on your other case or this case. Either way, you have some credit. And then that DNA surcharge. I do need to order your DNA. You need to leave here today. When you're out of the courtroom, you go out of the building all the way.
And that's where this case comes to a close. The court accepted the guilty plea, dismissed the remaining counts for sentencing purposes, and ultimately imposed 10 days of jail time already served, a $200 DNA surcharge, and monthly payments. What stands out here is how quickly the case moved once responsibility was accepted, but the judge's warning was crystal clear. The financial obligations were still part of the sentence,